Judgment in the matter of Hancock and another versus Commissioners for Her Majesty's Revenue and Customs.
Lady Arden will explain the decision of the court.
Mr. and Mrs. Hancock owned all the shares in a company, Bluebeckers Limited, and they sold them to Lionheart for some £9 million. In exchange, Lionheart issued loan notes which were redeemable on various dates. These loan notes were convertible into foreign currency. So they were not what the Taxation of Chargeable Gains Act 1992 calls qualifying corporate bonds, or QCBs. If they had been QCBs, they would qualify for an exemption from capital gains on redemption or issue. Rather, they were non-QCBs, and the gain arising on the sale of the Bluebeckers shares was deferred, or as it is called, rolled over, until the time when the notes were redeemed. At that point, the gain would be taxable. The same provisions applied to the conversion of bonds. It may seem odd that Parliament only granted an exemption for bonds if they were not convertible into foreign currency, but there was a reason for it, and that was because all Parliament aimed to do by the exemption was to encourage the market in sterling corporate bonds. Going back to the share sale, Mr. and Mrs. Hancock were content to accept loan notes to help Lionheart, but later they decided to redeem their notes. They consulted their accountants, who told them that they might be able to save some capital gains tax if the notes were restructured. Accordingly, on their accountant's advice, the loan notes were restructured by two further steps. The first of those two further steps was that the terms of some of the loan notes were varied so that they became QCBs. So some notes become QCBs. The second further step involved converting both sets of notes, QCBs and non-QCBs, together and without distinction in one lot into a series of discounted loan notes, or SLNs. These were QCBs. The SLNs were subsequently redeemed for cash. Now, Mr. and Mrs. Hancock say that as a result of these two further steps, the gain on the issue of the loan notes was not simply deferred or rolled over until the notes were redeemed, but were entirely exempt from capital gains tax because when they were redeemed, they had already become QCBs. This was because on the Hancock's case, Section 116(1)(b) of the Taxation of Chargeable Gains Act 1992, which is the exception or carve-out from the exemption for conversions, only applied to a conversion consisting of or including QCBs into non-QCBs, QCBs into non-QCBs, or vice versa, and not the conversion of a mixed unit of both QCBs and non-QCBs into QCBs. So the other conversions, the mixed conversions, could not be pigeonholed into Section 1161(b), and ensuing redemption were exempt from capital gains tax. The drafter, in other words, hadn't contemplated that there could be a mixed conversion or a conversion of QCBs into other QCBs. HMRC disagreed and decided that the Hancocks were only entitled to rollover relief and not exemption. The Hancocks appealed. They won before the first-tier tribunal, but lost before the upper tribunal and again in the Court of Appeal. As the first-tier tribunal pointed out, the relief under Section 116 for QCBs had been intended to promote the market in sterling bonds, and so the Hancock's interpretation would go well beyond that objective. The Court of Appeal decided that, although the wording of the carve-out from the exemption in Section 116 could be read literally in favour of the taxpayers, that result would be contrary to Parliament's intention and should be rejected. The issue before the Supreme Court is whether Section 1161B of the Taxation of Chargeable Gains Act 1992 applies where by a single transaction both non-QCBs and QCBs are converted into QCBs. By the judgment handed down today, the Supreme Court unanimously dismisses the appeal. I gave the judgment with which the other members of the court agreed. It was common ground that if the conversion was to be treated as a separate conversion of QCBs and non-QCBs, i.e. not as a single mixed unit, but as a number of separate units, the appeal must fail. There was therefore a question of interpreting the provisions of the Taxation of Chargeable Gains Act. The Hancocks had in fact utilized a single transaction, but that did not conclude the issue of interpretation. The Supreme Court considered that the answer lay primarily in Section 132, subsection 3 of the Taxation of Chargeable Gains Act, and that defined conversion. As the upper tribunal had pointed out, this provision makes it clear that the intention of Parliament was that each security converted into a QCB should be viewed separately from any other conversion or security. Moreover, the meaning which the Hancocks sought to give to Section 1161B was inexplicable in terms of the policy expressed in these provisions, which was to confer only rollover relief and not exemption in all relevant reorganisations. If their meaning was the right one, the taxpayers generally could easily avoid these provisions. In summary, on the true interpretation of Section 1161B of the Taxation of Chargeable Gains Act 1992, the desired exemption was not available in this situation. The potential chargeable gain within the non-QCBs was simply deferred on conversion or rolled over. It did not, to use the colourful words of Lord Justice Lewison in the Court of Appeal, simply disappear in a puff of smoke. Thank you.
The court will now adjourn.